Joe Dementia gets slapped down once again by federal courts. I'm Jasper Gonzo, and this is what's next. Hey, what's up, guys? Jasper Gonzo here. Another episode of What's Next, your daily dose. And of course, this is the weekend edition. I meant to do these videos yesterday, but from a health standpoint, I wasn't up to snuff. This week has been very bad for me, battling the flu. I think I'm on the tail end of it, but of course, as you can tell by my voice, it's still not where I need it to be. It's probably like about maybe 60-70% strength. But anywho, we move on. Well, it turns out Joe Dementia was trying to force state mandates regarding tranny madness. Federal judge steps in and slaps his ass down. Let's take a look. This comes out of the Daily Wire. Federal court bars Biden administration from forcing radical gender policies on states. A U.S. District Court judge in Tennessee has temporarily barred the Biden administration from enforcing a policy that would require states to allow athletes who identified as trans to play on sports teams with the gender that they, quote unquote, identify with. Yes, let's just call it the Will Thomas plan. On Friday, U.S. District Judge Charles Akeley Jr. ruled in favor of 20 states' attorney generals who sued the Biden administration in August 21, the Associated Press reported. The attorney generals argue that two federal agencies, the Equal Employment Opportunity Commission and the U.S. Department of Education, were overstepping their mandate from Congress by crafting new guidance that would have trampled upon existing or future state gender laws. In addition to affecting transgender athletes, the Biden administration policy would have allowed individuals who identified as other to enter locker rooms and use bathrooms of the opposite biological sex. Yes, if you got a ding dong and balls, basically you are going to be allowed to walk into women's locker rooms and drop trowel. But I'm a woman, so what's the problem? June 21, DOE said that discrimination based on gender identity would be a violation of Title IX. The EEOC also allowed new guidance for private businesses. Many of these states represented in the lawsuit had crafted laws that ran afoul of these federal policies and argued that the court needed to issue a temporary injunction on the federal guidance until the lawsuit could make its way through the system. Quote, as demonstrated above, the harm alleged by plaintiff states is already occurring. Their sovereign power to enforce their own legal code is hampered by the issuance of defense guidance and face substantial pressure to change their state laws as a result, Judge wrote in his ruling on Friday. Tennessee's Attorney General Herbert Slater led the lawsuit and claimed that the justification of DOE's and EEOC's guidance rested on the false interpretation that Boxtel versus Clayton County, which declared that discriminatory for a private business to fire or hire based on the gender identity, quote unquote, or sexual orientation under Title IX. These agencies also have misconstrued the Supreme Court's Bostock decision by claiming its prohibition of discrimination applies to locker rooms, showers, bathrooms under those titles, under Title IX and Title X. Biological men who identified as women competing in sports and women's sports, when the Supreme Court specifically said it was not deciding those issues in Bostock, Slater argued in August of 21. The lawsuit also said the Biden administration purports to resolve highly controversial and localized issues such as whether individuals may be compelled to use other persons' preferred pronouns, but the agencies have no authority to resolve those sensitive questions, let alone to do so by executive fiat without providing any opportunity for public participation. The Attorney General argued that the agencies in question were usurping authority that properly belongs to Congress, the states, and the people, to eliminate the nationwide confusion and upheaval that agencies' recent guidance has afflicted on states and other regulated entities. Prior to the injunction, DOE has enacted various state sanctions in schools and colleges that do not comply with trans guidance. Ultimately, the Attorney Generals challenging the administration want the court to declare the policies invalid and unlawful to prohibit their enforcement. The Dementia administration has recently suffered setbacks, massive setbacks, when attempting to enforce new policies on states in other domestic issues. My thoughts. There was a lot of lawyer speak in this article, but at the end of the day, when you have a federal court judge from Tennessee smacking down Joe Dementia's incompetent and stupid tranny madness policies, his mandates, trying to force states across the country to adhere to his will. 20 states filed a federal lawsuit and said no. The judge agreed that each and every individual state should make their own policy by legislature in regards to tranny madness. To basically just say no. Sorry. You're a girl, go in the girl's bathroom. You're a boy, go in the boy's bathroom. If you're a dude who attempts to go into the girl's bathroom, well, let's just say there's going to be problems. And I'll leave it at that. But this is where we are in 2022, where all the chips are pushed to the table. We saw what happened during Groomer Month, and it still continues to go on. Libs of TikTok still continues to feed videos or show us videos of just ignorance teachers forcing this garbage on kids as little as 3 years old. But yet, that's okay. But the second you speak up about it, oh no, now we got a problem. Now we have a problem. So, when you have the Supreme Court who shoots down Roe, finally, after 49 years, shoots down the New York forced gun control law, which of course, again, favors the coach who prays with his students at the end of the football games. Those are good things. Those are common sense things. Things well overdue, but common sense nonetheless. But when you have an agenda-driven, dementia-riddled old man who, not by his own thought process, but by those who are pulling the strings surrounding him, basically saying, listen, we need to push this tranny madness agenda, and I mean full throttle. When you have a White House spokesman or spokeswoman whose only qualifications is that she's black and she has a vag, and of course she's a lesbian, well, that's all you need. While the rest of us are going, wait, it's called qualifications. What qualifications do you have? No, you racist, you bigot. But it's always good to have federal judges step in and say, listen, we are not here. Our job is not to legislate law. Our job is to interpret law and to force states regarding this trans nonsense. Yeah, I'm not going to have it. So right now it's a temporary stay, temporary ban. I believe it's going to be permanent. I think other federal court judges are going to step in and say, you know what? Yeah, I totally agree. It should be up to each individual state, just like abortion. Leave it to the states. With that being said, I'm Jasper Gunzo. This is what's next. Want to see more just like this? Please leave a comment below. Like it, share it, subscribe to it, and we'll catch you guys on the next one. Peace.